All right, let's get started here. I think we have a lot of people registered for this event. We got a number of people who've filtered in already, and the list is growing. So let's just get started right now. Good afternoon, everyone. Thanks for showing up. My name is Kieran Shenoy, and I'm the Government Affairs Director for the Bridge Association of Realtors, your Association of Realtors. And again, we thank you all for joining us this afternoon for one of Bridge AOR's Local Government Relations Committee events. We have an extremely interesting and specifically pointed discussion about ADUs and illegal units today, with some excellent speakers that not only have a wealth of knowledge, but a world of practical experience. First, we have the co-chair of our Local Government Relations Committee, Steve Edrington, who's the president of Edrington and Associates and Adapt Dwellings. We have Philip Barthman, the senior building inspector with Edrington Associates and Adapt Dwellings. And to round it out, we have Steve Williams, partner with Freed Williams and Grice Connor LLP, that has offices in San Francisco and Oakland, real property attorneys that deal with a lot of issues that come up every day in the overregulated places of Oakland and Berkeley. So I'll leave it to them to kind of introduce themselves even more. And I hope you enjoy this presentation. Please, if you do have questions, enter them into the chat, and we will get to them at the end of the presentation at the Q&A section. Okay. Without further ado, the floor is yours, Steve.
All right, thanks, Kieran. Can you see my screen? Kieran, can you see my screen?
I cannot, not yet.
Okay, let me share. We're getting there. I love technology. Okay, now, all right. So let's launch this and get going here. Just 1 second here. I apologize, trying to get our. All right, so can you see my full screen, or is it just showing the slide screen?
It's showing the slide screen. So maybe.
Oh, okay. Yeah, let me switch screens. I apologize. It was working perfectly. And how that goes, right? Yeah, my thing is frozen at the top. That's my problem. All right, we'll get going. We'll change it real shortly. I apologize. So we'll continue to.
So
let me just flip the slides here. Yeah, I know that, Phil. It won't. It's not allowing me to do that.
While we figure this out, it looks like our president, Janine Hunt, is in the room as well. So hi, Janine.
Hi.
Right. Oh, and there it goes. Steve's got it figured out.
Sorry about that. I love technology till it works, and then I've gone on Zoom before and it works great. No, it doesn't. All right, so I want to do Steve Williams. He's partnered with Freed Williams and Grice Connor, and I've worked with this firm for many years. They're excellent landlord-tenant attorneys, and I know they've spoken to your group before, but they've hired me as an expert before, and I've actually hired them to be counsel for me before, so I speak high praise for that group. The other thing is Phil Barthman, who's our senior building inspector. He spent 20 years Alameda County Building Department, and he's an electrician by trade, and he does all of our feasibility work on ADUs. And then, as Kieran said, I'm co-chair of LGR, and I used to be the executive director and lobbyist for East Bay Rental Housing Association, and then have my own ADU business, and we can help from feasibility to architectural drawings. So I wanted to kind of go over the history of ADUs, and then we'll get into the legal things and the risk. And we're going to speak to you as I'm a real estate broker and things that I see out in the market. And we want to make sure that you do the proper agency, have the proper agency with your client and proper disclosures. And I think that's the thing that we want to walk away from and make sure that you are properly telling people what you need to tell them and not being sued once the transaction is done. All right, so we'll talk about ADU history and overview. Illegal units are a problem, and just in Oakland alone, there's probably 10,000 or more illegal units. There's a ton of them out there. We'll talk about their risks today. We'll talk about legalizing a unit, and we'll talk about financing, rent control, and more. First, I want to give a disclaimer. This is an educational event. We're not giving you legal advice. And Steve Williams would like to be your counsel, but he's not as of yet. So if you do need the legal advice, reach out to Steve Williams and he can help you out. So I wanted to get some terminology correct. So what is an ADU? There's a lot of things around terminology around ADUs that are incorrect, but an ADU is an accessory dwelling unit. There's always a primary dwelling unit, and this is accessory to the main property. But we know them as in-law units, granny flats, but basically it's a secondary unit, house or apartment with its own kitchen, bath, sleeping area, and its own separate entrance. So there's always a primary dwelling, and an ADU is accessory to the primary dwelling. All right, so we've had ADUs on the law since 1980s, and in 2020 there was a state law change that allowed ADUs in multifamily, and we'll talk about the difference. Previously, very few jurisdictions allowed it, and then we have a lot of illegal units, and a lot of it dates back to World War II when we had a huge influx of people to the Bay Area for the war effort, and there was a lot of houses that got cut up and turned into multifamily. So that's a lot. So, but I first want to give you kind of a 30,000 foot view on ADUs, and what I mean by that, it's a zoning overlay law. So the state has told the local jurisdictions that if you meet a checkoff list, that you have to issue the permit. You still have to meet state building code. We're in the 2019 building code, but it's a zoning overlay. And I think people miss that many times. It's a zoning. So the state controls building code, the local jurisdiction, San Francisco, Oakland, Berkeley, controls zoning. And this is a zoning overlay to the local zoning laws. All right, so why ADUs? Why are they popular? They help address our housing shortage. We're about 2 million housing units short in California. Actually, half of the housing shortage in the United States is in California. Generally more affordable, give property owners potential income, but politically they maintain the neighborhood look and feel. So every time there's a bill, Scott Wiener has several bills up state, he tends to not have enough votes because when they want to build a big apartment building, the neighborhood doesn't really like apartment buildings. So ADUs is a way to add housing, and it's politically palatable. The state now has removed a lot of local barriers. One of the reasons why we started our own ADU business, because we work a lot with multifamily owners. And so I'll give you an example. So somebody will have a fourplex and they have an illegal unit down in the basement. They've had it there for years, and they've gone to the local jurisdiction and say, hey, I'd like to legalize this. And the city says, no, it's zoned for fourplex and you don't have parking. Well, the state law actually overcomes that. So they don't care what the zoning is. If you follow their checkoff list or ministerial process, you can legalize it. And if you're within a half mile of a bus stop, you don't need parking. So that's a huge way to legalize units. It just didn't exist before. So let's talk about single family homes. So there's rules for single family homes and there's rules for multifamily. So you can add a new attached structure, build a new detached structure. And the most popular one is converting like a garage or a basement from a non-habitable space to a habitable space. So the local jurisdiction can restrict the size for a studio 1-bedroom down to 850 square feet and a 2-bedroom or more to 1,000 square feet. And I'll pick on Modoc County. So Modoc County is at the top right corner of the state. It's a rural county. most likely they don't have an ADU law. So if there's no ADU law, then the default is 1,200 square feet. So, but most jurisdictions are writing ADU laws. The big thing is height limit. The local jurisdiction the state has told the local jurisdiction you must allow 16 feet. I believe Oakland is at 18 or 20 feet. It just changed the rules. San Diego, San Jose are at like 25. But the most important thing is setback. So the state has told the local jurisdictions that you can have a setback at 4 feet in the back or 4 feet on the and 4 feet on the side. That's huge because if you look at the local zoning, it's usually 10 to 15 feet in the back, 5 to 10 on the side. So you can put a much bigger building and occupy, have a broader lot coverage area ratio. Let's quickly talk about JADUs. So if you have a single family home, you can add 2 units, 2 ADUs, a regular ADU and a JADU. And Phil, I want you to talk a little bit about, if you can explain a little more about what a JADU is.
Sure. The JADU is an easy way for a homeowner who's got some extra space inside their home to add a rentable space in their house that is somewhat separate. The cool thing about a JADU is you can take a bedroom, as long as it's a large enough bedroom, and you can add a small cooking area to it. And it's assuming that it's big enough. Then you can also use an existing bathroom. In fact, you can even share that bathroom. So the tenant and landlord can share a bathroom and still have separately rentable space. The downside of these, of course, is they are only allowed for owner occupancy. So the owner has to either be in the primary or the JADU unit to allow for this.
We're not seeing a lot of shared bathroom spaces that I've seen. Can you explain that a little bit more?
Oh, I think that it's fairly good, fairly common that people don't really want to share a bathroom given the choice. You know, that's what the state has done is they're trying to provide options for people so that we can get people into housing. I mean, and so they're trying to reduce as many barriers as possible so that we can get people into housing. In their way, they're trying to just reduce barriers and create more opportunities.
All right. So one of the main things between ADUs and single family homes and multifamily homes is in single family homes, you can actually chop up the house. You can take a 3-bedroom, 2-bath unit house and you can make it a 2-1 and a 1-1. So you can take habitable space and divide it. In multifamily, you cannot. So you cannot divide habitable space. They don't want landlords taking 3-bedroom, 2-bath rental units and cutting them up to 2-bedroom, 1-bath unit and a 1-1. They don't want to do that, but you can do that in single family is allowed. So with a junior ADU, you could literally have a 10 by 15 room, share the bathroom, put a kitchenette into it, and divide the house up into a JADU and habitable space. So that's one of the bigger options here. All right, let's keep rolling here. All right, options for multifamily, you can convert non-habitable space. And in Oakland, for every 4 units, so if you have, we looked at a building the other day that was 12-unit building. It had a huge basement. They could add 3, they can convert the basement to 3 units and they could add 2 in the back. So they could take a 12-unit apartment building and make a 17-unit apartment building out of it. So 4-foot setback, still the local jurisdictions are restricted to minimum of 16 feet. They can go higher, but they can't go lower. And same thing on the size. If you convert a non-habitable space, it must be within the primary building envelope. And then Phil, let's talk about S9 fire areas. This is Oakland and Berkeley Hills. Maybe just briefly touch on that.
Sure. And I hope, well, I guess I'm aging myself when I talk about the Oakland firestorm. A long time ago, we had a terrible, terrible fire in Oakland, and it really showed people what the vulnerabilities were in the hills around Oakland and Berkeley. Understanding that these streets were put in back in the old days of horse carriage and Model Ts, tiny little cars, and so we've got tiny little streets with very difficult turnarounds. And so basically what they've done is they've made it very difficult to add ADUs in a lot of the areas where it's going to be very difficult to get egress in and out. So in other words, it's difficult to escape from, and it's difficult for fire personnel and equipment to get into. So that's really what they're trying to cover there.
So if you're looking to add an ADU up Snake Road or Skyline, you may have some difficulties because some of the roads get very narrow up there and they just don't have good egress out of the hills into, Highway 13, 580. So just those are things that you have to take in consideration. So from what we can see and our clients that we talk to, it seems like the multifamily property owners are building the most of the ADUs out there. Their homeowners are definitely doing it, but we're seeing a lot of them in multifamily. So let's talk about ministerial approval. And Phil, what is ministerial approval?
So basically, on any other type of project that you're going to add, you have the planning department that has their own rules, and every different planning department in every different city has got their own unique sets of planning priorities and goals and so forth. What this does is it really takes planning out of the equation. Basically, what they've done is they've set many of the parameters that the planning usually has an opinion about, and they've eliminated that. So this whole law is a way to cut planning out of the equation so that you're much more likely to be allowed to construct something.
All right, yeah, so it's a checklist thing and it makes it objective. So they can't send you to the planning commission and have all the neighbors show up and object because they don't like, they don't like the fact that you're building an ADU. So it's helped to streamline the process. All right, so let's talk about what else is in the 2020 state law. Replacement parking. So replacement parking is not required if it's demolished for an ADU. Owner occupancy. This was actually geared towards City of Berkeley because City of Berkeley passed a local ordinance saying that if you added an ADU to your house that you lived in, that you had to live there. So the state law says, no, you can build an ADU on your single family home and you don't have to live there until 2025. Impact fees, affordable impact fees, a lot of different impact fees. If your ADU is 749 square feet or less, you don't have to pay impact fees. They can be tens of thousands of dollars. If it's 750 or more, it's prorated. And Phil, there was a project we worked on in Napa. Can you explain the cost difference on that?
Sure. So in Napa, they have a very interesting cost structure. If you were going to build an ADU up to 749 square feet, the impact fees, the permit fees, all of the costs that were going to get paid to the city were under $5,000. As soon as you went to 750 or 751 square feet, it went from $5,000 to almost $30,000. So it's just a crazy difference in those areas. And what they're doing is they're maintaining the look and feel of their areas by insisting on smaller ADUs.
All right, great. And building permit fees are running around 7%. So yeah, so if you're adding impact fees on top of that, it can get very expensive. So zoning correction, let's talk about zoning corrections. And I think we've all seen this. Hey, it's legal non-conforming. Well, I have a duplex on the site, but it's single family zoning and it's been there forever. So if you wanted to add units in the past, they would say, hey, you're legal non-conforming. You already have too many units on that lot, more than we allow in our current zoning. State doesn't care. We don't care what the zoning is. If it's legal non-conforming, you can still be more, you can be more illegal, it's fine. Building corrections, and I think this is a tricky area, and Phil and I have worked on this. If you get a notice of violation from the local building enforcement, so it's code enforcement in Oakland, it's DBI in San Francisco, you can go to the building official and ask the building official to delay the enforcement of the notice of violation. But Phil, let's talk about that. There is a thing called the health and safety code, and you need to meet that. I don't see any building official allowing a delay if there's health and safety problems.
And that's exactly right. And the problem that we run into is, okay, well, what are they going to consider to be a health and safety issue, right? Is ceiling height a health and safety issue? I mean, it's a really hard stop for most departments. You have to maintain a minimum ceiling height. But, obvious stuff like sanitation, or proper electrical and things like that can very easily be problems, that can be health and safety problems. So it's really going to be up to interpretation in a lot of this stuff. It's not one of the areas in this law that I think is really strong that you should think of as a go-to, because you're going to be able to use this in very unique and in minimum circumstances, really.
Steve Williams, I have a question for you. So we're talking, so just because I have an illegal unit and I was, let's say for example, I was able to go to the city of Oakland and the building official said, fine, we won't enforce NOV. That doesn't give me a certificate of occupancy.
No, that's right. And we'll get a little bit into this later. But the bottom line is just because the city sort of looking the other way on this does not necessarily render that unit as permitted for separate occupancy and therefore a permitted rental unit. And there are some ramifications and risks, which we'll talk about in a moment, that come with renting a unit that has not been approved for separate residential occupancy. You basically receive that certificate of occupancy.
Right. It's not the certificate of occupancy is your get out of jail free card. It's not the delay of the NOV.
Well, so to speak, as Kieran mentioned, these overly regulated areas, I think you're still in jail, but maybe you can sort of come and go occasionally.
There's visitation privileges that are expanded or
subject to the rent control laws.
Right. All right. So let's talk a little bit about HOAs. And this was silent in the law until 2020. And basically what the state said, if you are in an HOA, the HOA can't straight prohibit an ADU. So we see a lot of houses that are in homeowners associations. They just can't blanket, no, you can't have an ADU. So they must allow provisions for it. And you will see it in homeowners associations where there's homes. Multifamily type HOAs are a little more difficult. But let's go into a legal unit. And I think there's a lot of misconception out there. I know there's a lot of misconception because we run into it all the time. What is an illegal or unpermitted unit? And it's a unit without a certificate of occupancy. And Phil, I want you to comment on this because I see people with houses and they say, but I have a certificate of occupancy for a single family home, but they don't have a certificate of occupancy for a single family home with a separate unit. Can you talk about that?
Sure. Yeah, it's so important that the certificate of occupancy specifically describes what you've got going there. We had a case where some people bought a triplex. It was 2 units with an ADU, and they had a certificate of occupancy that identified as a triplex, but come to find out when you read that certificate of occupancy, it did not describe what they had at all. Somebody had gone in and completely remodeled and reorganized the space without permits. And so while they were holding a certificate of occupancy for 3 units, the 3 units that they had weren't the way that it was on the certificate of occupancy. So that C of O was basically waste paper. It did not do them any good. You have to have a certificate of occupancy that specifically describes what you've got.
Sorry about that. I want to go back to the slide here. All right, so how do you go about legalizing it? And generally, our experience with adapt dwellings and our architect is the city will want to know what's existing and what you're proposing. And usually it requires a set of plans and a process through the city. And Steve, I want to get into, generally there's problems when tenants are living there and it's an illegal unit. And in order to do work in the unit, we're going to have to ask the tenant to leave because the work, we got to open up sheetrock, we got to do electrical, we got to do plumbing, and that tends to be problematic. Can you talk about that?
Yeah, so it's easier said than done, and it really is going to depend on which jurisdiction you're in. Um, most of the jurisdictions do have a basis to ask a tenant to temporarily vacate in order to conduct certain construction or repairs to a property when that construction or repairs will render the unit uninhabitable while work is going on. Now, you can only displace the tenant for the minimal time needed to perform the work you need to do. And there's usually relocation payments that are associated with that. And the tenant has the right to immediately come back upon completion under the same terms and conditions of the tenancy as they existed prior to conducting that work. Depending on where you are, there is generally an avenue to ask the tenants to temporarily move to perform the necessary work. But like I said, it's easier said than done. There's oftentimes a lot of red tape with that.
So Steve, this is kind of where this is where landlords get sued for wrongful eviction. And I know in Oakland, there's filings with the rent board. And then when you do the temporary termination of tenancy, you have to pull a permit, attach it to the notice, and you gotta do the work within a certain amount of time and then allow them to tenant back. And one of the things with COVID, and actually I'm working on a case right now as an expert, where the person did that, the tenant moved, and they've been working on it for like 1.5 years, 2 years. So maybe you talk about that. So this area is like really fraught, and this is not a do-it-yourself project. They need to hire somebody like you to make sure they get proper notice, file with the rent board the correct documents, and make sure that they're staying on a timeline. And if they don't stay on the timeline, there's a procedure to notify the rent board and the tenant. Maybe you can talk about that.
Yeah, especially when you've got a project that's going to displace tenants for that length of time. It's not uncommon that clients come to me after having struck a deal with a tenant to, temporarily go stay at a hotel, maybe for a week or two. Now, whether that's lawful or compliant under the ordinance, that's a separate question, depending on which ordinance you're referring to, which local rent control ordinance. But that's not uncommon. But absolutely, when you are undertaking a project that is going to displace the tenants really for any period of time, especially for months, or in your case, a year. I had one where the tenants were out for 2 years. Then you absolutely have to comply with the local codes, the local ordinance, and give proper notice, which in most circumstances would be a formal 60-day termination notice, albeit temporary, with your relocation payments and your citations to the code. And oftentimes, again, depending on your jurisdiction, if the displacement is going to be longer than 3 months, for instance, in Oakland and San Francisco, you have to go get approval from the local rent board. So in Oakland, you have to apply for approval to displace the tenant for more than 3 months, and same thing in San Francisco. Now, to your point about lawsuits, and I'm happy to talk about that now. I don't remember if we have a slide coming up on that, but in short, and I tell clients this all the time, and I seem to see during the COVID time, the tenants advocates, lawyers making their living by filing lawsuits. I seem to see those were still going strong, even though evictions weren't going strong during the whole COVID pandemic, yet the tenants were still filing lawsuits. And a very common one is breach of the warranty of habitability, or illegal units, renting a unit that is not permitted for occupancy. And I tell clients all the time that that's, really fish in a barrel for these lawsuits. You automatically have a claim right there. There's a habitability claim, and there's a claim that, hey, you rented us a unit that's not permitted for occupancy. We would have never moved in had we known that. Now we're being asked
and
to
it's
leave.
fraud. They're claiming fraud too.
Fraud, yeah, fraud, and just renting a unit that's not permitted. California has a law that basically voids any contract that is for an illegal purpose. That's all contracts. And of course, a rental agreement is, whether oral or written, is a contract. And so if that contract is for an illegal purpose, that contract is then void. So a rental agreement for a unit that's not permitted for occupancy is arguably voidable and not enforceable. Now, in the old days, we used to say if the tenant raised that argument, well, okay, that may be true, but you're not entitled to be there. As a result, if the contract's void, you tenant have to move out. And we used to get, we used to make some headway with the courts with that argument. Not anymore. Those units, even though the tenant has maybe asserted a claim like a wrongful eviction or a habitability claim or attempted wrongful eviction claim, that they're being improperly displaced from their unit, which is illegal. Well, the courts have said, well, the tenants are still entitled to the protections of the eviction control ordinance and the rent control ordinance, even though that contract may be voidable. What that means is then you have to have just cause under the local ordinance to displace them. And you can't just say, well, you raise the argument, it's an illegal unit, therefore you must go. No, you have to give a lawful eviction notice, which in Oakland, there is a just cause to ask a tenant to move out in order to remove a unit from housing use. So if, let's say, instead of legalizing that space as an ADU, you decide, you know what, I want to return it back to a storage space or whatever it was before. You can do that in Oakland, and that could be a cause to terminate the tenant's tenancy. Another cause to do so would be what's known as the Ellis Act, which is remove the entire property from the residential rental market. So those are two avenues that you could ask the tenant to permanently vacate in that circumstance. Or as you've advocated here, you could potentially legalize the unit, and therefore the tenant has nothing more to complain about once it becomes permitted. But the fact that you've rented that unit does not or it opens you up to potential liability for wrongful eviction and habitability claims.
All right, so Steve, a couple things from a broker agent point of view. We want to make sure that we don't say, oh, there's a rental unit back there if we don't know that it's a lawful unit. And a couple of telltale signs, and feel free to jump in here. The unit has a low ceiling height. There's no window in the bedroom, inadequate heat. Some things are just telltale signs. And we have agents call us say, hey, I'm getting ready to list a house in 2 weeks. Do you think you can legalize it? And the answer is no. It takes months to go through the process and get it legalized. So yeah, this is not a short, let's fix it, because there's the paperwork side and there's the physical part. And Phil, maybe you can talk about the physical part, the electrical, the plumbing, the heating, bringing it to the 2019 building code. And if I have an old 60s house with an illegal unit that's been down there for years, that could be a substantial amount of work. Maybe you can talk about that.
Yeah, no, that's really true. I'm always surprised at how long people go without doing any remodeling to their house, especially electrical. Electrical seems to be the last thing on everybody's mind, but it seems to also affect them the most. So when we're dealing with a unit, as an example, you have to have 2 dedicated circuits for the kitchen appliances. You need to have lighting in all the rooms. You need to have proper switching. There's so much that goes on. And then right now, in San Lorenzo right now, there are still homes that have got 30 amp services, single phase. And how it is that people are existing with modern appliances on something like that just defies my imagination. And so electrical is a big one. Plumbing, when you want to add bathrooms and stuff like that, many times you're going to need to increase the size of the water. We all have seen those commercials where the revive guys talk about, oh, don't flush the toilet, I'm in the shower. Well, sometimes that has to do with old pipes, but a lot of times it has to do with too many plumbing fixtures drawing on the water. So, these are all things that need to be considered. Heating is another one. And tenants complain a lot about heating because a lot of landlords think, okay, well, I'll just slap a wall heater in this, 2,000 square foot house and call it good. And that's not adequate. Wall heaters, I mean, if it's cold, even here in the Bay Area, if you had a wall heater in a big house like that, you could have that thing on 24/7 and it still wouldn't adequately heat the home because it's got to heat the whole home, not just the area right around the wall, the heater. So, again, these are all considerations that need to be made when you want to legalize something.
All right, for brokers and agents, let's talk about duty of agency and disclosures. So you have a duty to look out for your client, number one, and two, as we say in the business, if in doubt, disclose. So most of us are working in what we call material disclosures. And I explained this to my client, and Steve, feel free to jump in here, that if you were sitting on the other side of the table and the seller told you that there was a problem with the building, if you decide, hey, I wouldn't want to buy that building, or I would give a whole different price to that building, it's probably a material disclosure. And so yeah, you need to make a material disclosure. And the last thing that you want to do is say, oh, there's a rental unit downstairs and you don't know what the status of the unit is legally. I think you should say, I don't know. That's a fair statement. And also direct the buyer to do further investigation. And the last thing you want to do is not say anything and rely on your quote, our boilerplate language and then get sued because, Phil, we actually are working on a suit and maybe you can talk about this. What happened?
Yeah, perfect example. This woman was buying her very first house. And the existing owner evicted the tenant living in the unpermitted downstairs basement area. And that tenant basically filed a retaliatory complaint to the building department. The building department came in, wrote a notice of violation, and this was happening during the transaction. And so, of course, we've all dealt with buyers. They're all very excited and want to get that house. And so they said, oh, well, hey, this other thing just came through. You need to sign off on the fact that this is an illegal space. And being an uneducated in real estate person, this person signed it and said, okay, great. And then she proceeded to rent the thing out. And when the city writes a notice of violation, they don't forget. They keep coming back. And so basically now what she had a tenant in an illegal space with a notice of violation. And so now she is having to expend money on lawyers. She's having to pay the tenant to leave. And
this is a new tenant. This is a new tenant.
Yes, exactly right. This is the tenant that she brought in. And now she's also going to have to pay to convert that space from an ADU back to the unhabitable space that it was. We did a feasibility study on this thing, and the problem was she had a ceiling that was well below 7 feet. And so because of that, converting this into habitable space would have been prohibitively expensive. And so she is just really taking it in the chops with all of these expenses that she's having to pay out. And, right now we don't know what other legal ramifications are going to happen, but I would suspect, depending on how the realtor handled it, that they might be seeing a suit.
Yeah, so this person walked into a legal unit, tried to rent it out and got caught. You don't want to be the listing agent or the buyer agent, and that happens because guess what? They're going to come after you and your E&O. And even if you're right, a lot of times, your carrier's having to pay at the table, and you want to make sure you avoid this like the plague and you properly disclose. I don't know what the status of that unit. Buyer, you should check it out. Or it's a non-conforming unit. Please do further investigation. It's not. So Steve, talk about this. I know we probably told you a story you've heard a million times, but yeah, agents and brokers don't want to be involved in that.
And I agree with your rule of thumb that, just disclose. If you're thinking about it, well, should I disclose this? Or, well, maybe if I do, disclose it. If you have to think about it, it's probably worth disclosing. I mean, there's no harm. In fact, you're going to protect yourself more by disclosing as opposed to not. So, the buyer needs to be as educated as possible. It doesn't mean you need to go out and do, homework or research yourself on the necessary issue. But, and sort of to Phil's point, you can, if it's a single family home and there's an in-law space that's being rented or used separately, you don't want to just throw it out there as a duplex. You can say, I have this certificate of occupancy. Well, yeah, but look at the certificate of occupancy. What does it say? If it says single family home, then that's what it is, notwithstanding the use. So you're not disclosing that as a duplex. That would be disclosed potentially as a single family home with a non-permitted, in-law or an in-law that's being used as a residential unit without permit. So you really need to be careful about, as you pointed out earlier, how you represent a property, notwithstanding how it's being used. And again, sort of the go-to there is we'll take a look. What does the certificate of occupancy say?
Right. Spend the time or ask your seller to provide it if you have a question. So Phil, I want to do the flip side, because we've helped a lot of agents. They call us, they get in contract. And I know recently you were out at a property and they were thinking about buying this building because it had a unit out back, and you determined that the original structure was illegal. Can you talk about that?
Yeah, so one of the things that we do when we go out to do a feasibility study on your project, whatever it is, we do the research on the property. And this one house, we saw that they had built an ADU out in the back. And very quickly, I could determine that this was an illegal ADU, definitely not permitted. There was just so many different problems with it. And in doing the research, I realized that the building that they had used was probably just an old unpermitted shed. And so, I mean, there was nothing good about this thing, and it added zero value to the property. And somebody had spent a lot of money to bring this thing up to the level that it was. And honestly, they shouldn't have received any extra compensation for it because of the status. It was a nothing, basically.
Right. So one of the things that we're looking for, if you're going to convert a garage, that it's a legal garage. So it can't start off as an illegal shed with no permit, and because you can never get it legalized. And one of the things on garage conversions, we're actually doing one right now where we're taking the space up and expanding it, is a lot of the garages aren't worth saving. We have a garage, the floor is cracked, there's a lot of dry rot in the walls. It's not worth it. We're going to tear it down, utilize the footprint so we can be at zero lot line on part of our building. But a lot of the garages are just not, they're garbage. They're done. They're not worth spending the money on. So yeah, so the other thing that we can help agents out is if you get into contract and you think, oh, I think there's a potential ADU, I'd like to convert the basement of garage, give us a call. We can come out and do a feasibility study and give you our opinion about, is it really worth it? Sometimes it is, sometimes it's not. I tell clients the best money you can spend is getting to know very quickly. So people, to help people out. So let's continue to talk about certificate of occupancies. All right. So it's not uncommon for a single family home to have a certificate of occupancy only as one unit. We talked about that. There are thousands of units in the region without certificate of occupancies. And Phil, let's talk about really old stuff. 1890s, West Oakland. What about the paperwork on that stuff?
Yeah, well, especially in Oakland, we've got a lot of problems with the old stuff. Apparently there was a flood or a fire or something, and Oakland lost a lot of the records for their very, very old buildings. So it's kind of a head scratcher when we get into deep research on these things. And you hope that there's enough paperwork there to put together exactly what's going on. And if the property is turned over, there's probably going to be some paperwork that's going to send you in the right direction. But if it's been held for a long time and they've had no work done on it, you can really be stuck. And, a lot of people, say, well, it's my house, I can do what I want. And that's true to a certain degree, but you start to wonder where the original house ended and where all the other addition stuff started. And there are ways that we use to determine these things, but it takes a lot of research, and sometimes you have to do demolition and things like that to really find out what the original structure was, how things were built, and what needs to be rectified to get it back on track.
You can also ask the local jurisdiction, especially the city of Oakland, for a thing called a 3R report. And a 3R report is basically a statement from the building department of what they see at the property. And they will go through the file, they will determine. Now, there's many times that they're wrong, but if you can get the 3R report to state what you need it to state, because that's what it is, that's really something good that you can disclose and say, here's the 3R report, that this is what the city is saying is legal at the property. I highly recommend them. If many times the 3R report's wrong. Steve, we worked on a project for you where the 3R report came back and the building had been demolished and a new one had been built, and the city didn't pick it up on their 3R report. So we can go in and challenge them and do that. So we talked a little bit about rental agreements. So Steve, you said illegal purposes are void. It's a contract, and generally the tenant can walk away without a lease and the landlord can get sued. And generally on this lawsuit, Steve, what I've seen is everything is going fairly well until there's an issue for like non-payment of rent. And then the tenant goes to legal aid and and they figure out that it's not a legal unit. And then I see here comes the habitability, warranty of habitability, and constructive eviction, or the tenant will move out and say, this is not safe and I'm moving out, and then they sue the landlord. So I can almost go down the causes of action, including the kitchen sink, and you see these things over and over. Maybe you can talk about that.
Yeah, that's excuse me, that's right. As you mentioned earlier, there's thousands of these units in the Bay Area, but we don't have thousands of tenants suing their landlords. No, to your point, most tenants in most of these situations, they provide very valuable housing, usually at a lower cost than a traditional rental in a permitted space. And the tenants are more than happy to live there. And there's usually, no rift or no lawsuit. It comes to my attention when there is the lawsuit. And how'd that come about? To your point, again, maybe the tenant fell behind in rent. Maybe the tenant complained about, a leaky faucet and the landlord ignored him or her. So some little rift between the landlord and the tenant. And then lo and behold, that blows things up. The tenant goes and talks to the rent board or finds out this is a non-permitted unit. And like I said, those lawsuits are fish in a barrel for the tenants advocates. And you're right, I've seen, virtually identical lawsuits filed by, some of these tenant firms where I can see they just cut and paste someone's name from one template into another one. In fact, I even think I remember seeing one where they had the wrong name in it. So they crank these things out and they just—
I've seen the wrong cities in them. Yeah, they'll do one in San Francisco, no city, Oakland. Yeah,
you've seen it too. So it's real easy for them to crank them out, and if it's an illegal unit and the landlord rented it and is accepting rent, then there's a cause of action right there. It's an easy cause of action. Now, whether it's worth hundreds of thousands of dollars or not, that's a case by case situation. But it's very easy for the tenant advocates to do, and it usually does arise out of some rift between the landlord and the tenant.
So Steve, from a broker agent standpoint, so you sell a house, it has a questionable unit, 6 months, a year goes by, there's a problem between the landlord and tenant. The tenant sues the landlord because I'm living in a illegal unit, and then the buyer says, my agent never told me about that. And then couldn't they counter sue and bring the agent in?
So here's the problem, or the issue, is that the buyer, the new owner, steps in the shoes of the seller, the prior owner, as it pertains to that landlord-tenant relationship. So that landlord, the new owner, may have not been the one to rent that particular tenant, but if if there's going to be a lawsuit because it's an illegal unit by the tenant, then that person's going to get sued. And if it was not properly disclosed by the seller or the seller's agent, or if there was some misrepresentation in that purchase sales contract or the disclosures, then absolutely there could be a potential claim against them for that.
Yeah, that's why, proper disclosure is huge. I mean, if people want to buy a building with an illegal unit, that's fine. You can do that, but they just need to go in with their eyes wide open and know and understand that they'd have an opportunity to go seek counsel and understand. And I've had people said, I'm fine with that. Thank you for telling me, I'm okay doing that. And I said, well, you're taking the risk. So people go, well, okay, so is it really a big deal? And let's talk about damages. And we do expert witness work in the landlord tenant area as well. So here's kind of what I've seen. So the tenant moves out or says they were wrongfully evicted and they were paying $1,000 a month, for example. And they bring in an appraiser and they say, well, the fair market value of my unit is $3,000 a month. And I was going to live there for the next 20 years. And so that generally is the argument that I've seen. It's called rent differential. And so they want the difference between what they were paying and what they had to go out in the market and pay. And so people say, well, okay, well, that's kind of crazy. But if you take $2,000 a month for the next 20 years, that's $480,000. So those are the measure of damages. And then when they go to court, let's say the court says, yeah, that was a mean old landlord. He wrongfully evicted the little old lady and he's entitled, they were going to live there for another 20 years and they were, they struggled. And then, I've seen cases where the tenants were homeless after the fact. But what I think people don't realize is the jury is never going to hear the total story. So let's say, for sake of argument, that maybe it's not $480,000, maybe it was just $250,000 of damages. So they award the tenant $250,000 of damage, and the jury thinks, oh, that's great. But what they don't realize is when the judge is going to treble it because the local jurisdiction says 3 times the actual damages plus attorney's fees. So you could easily go from a $250,000 judgment from the jury award to a judgment of $750,000 treble, plus the attorneys comes in with another $250,000 of attorney's fees. So what the jury thinks is $250,000 of damage could turn into $1 million award. So can you talk about that a little bit?
Yeah, first, one I want to talk about a case out of Southern California about 5-6 years ago. This was the rental of, this was in Los Angeles, the rental of a non-permitted unit. And the tenant stopped paying rent. So what did the landlord do? They served a 3-day notice to pay rent or quit. Makes sense. That's what we would have probably done up here too at the time. And the tenant, didn't pay. An unlawful detainer was filed. The case went through the court and actually went up through an appellate division down south. And the final disposition was, hey, landlord, you've got the wrong notice. You cannot evict this tenant for non-payment of rent. And here's why. Because remember, contracts for illegal purposes are void. And a void contract, what's the rent? It's 0. So any amount you state in that 3-day notice to pay rent or quit will overstate the amount that is actually due, which is 0. So that case, again, it was in LA. It's not necessarily controlling here, but it is definitely persuasive. And I can tell you the judges up here will probably construe it the same way. So that's another risk in renting these units. While there's thousands of them, most tenants are happy and they pay, but it's when they don't, when you run into these issues. So you have to come up with one of those other avenues to potentially displace the tenant in that circumstance. And it may not be a non-payment of rent notice. So you could have a tenant not paying rent, and now you have to go through the process of some other type of eviction, which can take months or even a year or more. In the meantime, you're getting no rent. But now to your point on the damages, another case I want to give as an example, and you're absolutely right. The jury is not aware that local rent control ordinances like Berkeley, Oakland, San Francisco impose trebling of damages, which means whatever the jury finds for the most part as the tenant's damages, they're automatically trebled by these ordinances or tripled. And the jury doesn't know that. So the jury could think, well, the tenant's entitled to X for their, for their problem, their damages and their issues. And they leave thinking, well, we gave them a fair return. Well, that's going to be tripled. And the example I have is a case. This was it was an Oakland case, and it was probably maybe 10 years ago or so. It was 12 tenants sued a landlord, and the jury came back and awarded each of the tenants between $7,500 and $12,000, roughly, each of the tenants. So there's, like I said, about 12 different tenants. So it came out to about $125,000, if I remember correctly, in damages that they awarded. So the jury deliberated, and they spent a lot of time, and they felt this tenant was worth this, was entitled this much, this one this much, this much. So $125,000. Well, as soon as the jury left, automatically that went to $375,000 because of the trebling. And then came the attorney's fee claim. So the other side, as the prevailing party, the tenants were entitled to recovery of their attorney's fees. Mind you, they never paid it because most likely, and I'm almost 100% certain, this tenant advocate and law firm was working on a contingency fee basis, but they are still entitled to recovery of the reasonable attorney's fees. Well, guess what the court found was reasonable in that circumstance? A shade over $1 million. So you have this really $125,000 award that got trebled to $375,000, plus the $1 million tail that wagged the case of attorney's fees. So now you're up to close to 1.5 million here. So that's an example as to how these damages can really be amped up. And again, the jury had no idea about the attorney's fees that would also be awarded or that the tenant was entitled to. So again, these are all, and I don't mean to scare everyone here, but it doesn't have to be an illegal unit for a potential claim to come against the landlord, but renting units that are not permitted for occupancy does raise these risks and potential issues and consequences.
So Steve, the real thing where you want to be is that when the landlord gets sued by the tenant for a illegal unit, you want to be in a position, I told you so, and I told you so in writing, and you knew about it going in, so don't blame me. I told you.
That's right. One of the potential damages could be fraud or misrepresentation, that the tenant was somehow led to believe that the unit was a lawful or permitted unit. So that's one measure of damages that a tenant may be entitled to in those types of claims. But if the landlord, made the decision to rent a unit that's not permitted, knowing the risks, the least they could have done to minimize that risk is to disclose it to the tenant that this unit is not permitted for occupancy. So then the tenant goes in with knowledge and can't later come back and say, you committed fraud. I would have never moved in. I would have rented this place over here, instead of moving in here because it was disclosed. Again, just a simple disclosure that can reduce. It's not going to reduce all your risk to nothing, but it just, again, reduces one of the risks to an element of damages.
Right. And then from the broker agent standpoint, disclosing it, hey, it's a non-permitted unit. We can't find the paperwork. It's showing as a single family home. Please do further inspection. So when this thing blows up down the road, that they're not the buyers and saying, well, they didn't tell me. Well, no, I did tell you.
That's right.
And I did it in writing. You signed for it. So, and I think that's going to go a long way to helping preserve your errors and omissions insurance. All right, let's talk about practical courses of action. Don't rent illegal units. That's pretty basic. Don't represent the legality of the unit. The tenancy and the unit are protected and treat them as such. Make sure you have errors and omissions insurance if you're an agent broker, and if you're the landlord, make sure you have a landlord policy. And we see this happen. They have a house, they move out, they rent it, they still have a homeowner's policy, and being a landlord is a business and there's no coverage. And then also get help on legalizing units, as utilize Steve Williams, and he can tell you how to get it to vacant so we can do the repairs. But let's talk a little bit more. So there's a lot of opportunity out there. So as a broker agent, I have somebody who's come to you and says, hey, I'd like to buy a house. I want to put an ADU on it. Tell us about the building code. So Phil, let's talk about building code. So we know the state law has said there's a ministerial process through the local jurisdiction to get it approved through planning. But let's talk about building code considerations and all the different crazy things that you got to think about.
Yeah, so this is something that a lot of people don't consider when they're considering an ADU. They think, oh, it's going to be a walkthrough, and that's not really true. The ADU law is great for planning, doesn't do you any help for building code. So depending on where you're at, if you're in San Francisco, you need to have a minimum of 7'6" ceiling height. In Oakland and other places that have adopted the California residential code, it can be as low as 7 feet.
And
Okay,
Phil, I'm going to interject here. Finished ceiling height.
And that's what I was just going to get onto. So here's the thing. When you're going to, let's say that we're going to consider adding an ADU to a basement space. Well, one of the things that you have to have is not only do you have to have a firewall between those spaces, you also have to have soundproofing between those spaces. So that is going to add extra inches in between those units. So you need to have enough ceiling height on the rough space to allow for all of those different things. You need to have egress or ingress. So that's a couple of different things. You need to have a private entrance. You cannot enter your ADU through the existing house. It has to have its own private entrance. Your bedroom windows have to be escape bedroom windows. So they have to be of a minimum size. The sill heights have to be right. There's a lot of things that need to be considered as far as escape windows goes. Separate utilities. If you've got a separate address, you're going to need, if you've got just an all electric unit, you're going to need a separate electrical meter and a separate electrical service. You can't sub-meter. And what that means is you can't put a meter downstream of the meter that you've got because PG&E won't allow that. PUC rules are very strict about utilities. You have to have your own separate heater. So you can't just zone a single heater to deal with 2 units, not allowed. You have to have a separate heater with its own control, and it needs to get the unit space up to at least 68 degrees. Sound, and I talked about that, you need to have sound deadening between the units. One of my favorites is the deadbolt, and government agencies have got a bad habit of basically stabbing each other in the back. And this is a great example. If you go to the police, they're going to tell you, oh, you want to have a double key deadbolt because otherwise, they can break through the door and reach in and turn that lock. Well, the building inspector is going to say, oh, heck no. You absolutely have to have a handle, a non-key, but it's got the little handle unlock mechanism on the inside. So if there's an emergency, you're not running around looking for a key. And people say, oh, what if I just leave the key in there? Well, what's the point then? If you're just leaving the key in there, you're not doing anybody any service. You may as well just get the correct deadbolt. Now, these are just some of the big things that we're talking about there. There's so many other issues that need to be considered and that we talk about when we do a feasibility report on a property.
All right, so Phil, let's talk about some of the projects we're working on. So this is a garage conversion down in Pacifica. So it's under construction. So this is a typical garage where it could be converted. This is the interior, has a really high ceiling height. And let's talk about garage floors. Those are popular items. They're not meant for habitable space. So in this particular case, I think we're sealing the floor and building up a floor over it. Phil?
Yeah, that's correct. Yeah, when garages are built, they're never intended or designed to be habitable space. And one of the things that you're required to have is a vapor barrier in the concrete slab if it was habitable space. So if you don't have that vapor barrier, to add a vapor barrier would be basically, okay, we jackhammer up that whole slab, put in crushed rock, lay the vapor barrier down, and then pour a new concrete slab, which is expensive, time consuming, and not the easiest way to go. If you got, like, for example, in this situation, plenty of ceiling height, instead we can just build up on top of that floor and create our own vapor barrier just on top of the floor. Normally, though, you can't paint or use a coating on the garage floor and think that that's going to be considered adequate, because that's not adequate for vapor barriers.
A lot of little things. So let's get into financing options, because next question is, hey, I got this space that I want to convert to an ADU, create some income, but how in the heck am I going to pay for it? Well, we're seeing a lot of clients' existing savings assets. Probably the number one thing is actually cash out refinances. We're starting to get a little more expensive money, but we've been in a period of cheap money, and we still are. Home equity lines of credit, not so much. They seem to be harder to get after the 2009 crash. Fixed second rate mortgage, they're out there. They're not as popular. But there's also non-traditional options, including construction and renovation loans, cash out from a bank statement, or debt coverage ratio loan. So there's some alternatives out there as well. But let's talk about some of the challenges in financing. If you have a single family home, you can get Fannie Mae, Freddie Mac money, but they're not going to count the rental income in the ADU. So you're going to have to qualify on your own income to get it. 203K money out there for adding ADUs to single family homes or converting. They're out there. They're complicated, really hard loan to get, and if you're trying to buy a property in this housing market. 2 to 4 units, Fannie Mae, if you add an ADU to your duplex, triplex, or fourplex, you're no longer eligible for Fannie Mae, Freddie Mac money. So that's something you have to keep in consideration when you're adding ADUs to 2 to 4 unit buildings. 5+ unit buildings or commercial loan, they don't seem to care whether it's rent. They're using a debt coverage ratio anyway, and I haven't seen any restrictions on lenders on 5+ unit buildings. So a lot of single family homes, a lot of 5+ unit stuff. Kind of the missing middle, so to speak, is 2 to 4, just because of some of the difficulty of financing, and there's some alternative financing. We had a webinar last week on single family homes about using reverse mortgages to build ADUs on single family homes. Completely possible. We're actually going to do another presentation here shortly in next month on using reverse mortgages to finance your ADU. All right, let's talk about something dear and near to Steve Williams' heart: rent eviction controls. So the state under AB 1482 says if you build a brand new unit, whether it's a regular unit or an ADU, you're exempt from rent control for 15 years, and then you follow state law. I want to put a caveat here, and Steve, you can jump here too. A lot of jurisdictions, and I'll pick on San Francisco, all units are covered by eviction controls and tenant protection ordinance. So you may have an exemption from rent control, but you don't have an exemption from eviction laws and tenant protection ordinances. Steve, you want to chat about that?
Yeah, that's correct. So if you're in one of the local jurisdictions, particularly San Francisco, all rental units, very, very few exceptions, but generally all rental units are subject to eviction control. So this 15-year exemption generally applies to units outside of those stricter local jurisdictions. And one thing is that does apply throughout even local jurisdictions is the Costa-Hawkins Costa-Hawkins rent control exemption, which means single-family homes, even in San Francisco, Berkeley, Oakland, are generally exempt from rent control. which means you could generally raise the rent to prevailing market rates on an annual basis, notwithstanding the local limitations. Now, once you begin renting a portion of that single family home separately, an in-law unit, whether permitted or not, even if it's not permitted, then you have created essentially a duplex in the eyes of local rent control, meaning it is no longer exempt as a single family home from local rent control. And in fact, a recent decision came down in Oakland, which was a bit concerning. This was a single family home where an owner rented, I think it was 3 or 4 rooms in the home. It was a big house, 4 or 5 bedrooms or something. And they rented rooms to tenants. So, I have a room here, a room here, a room here, all sharing the same kitchen, the same, common areas. Well, the decision came down at the rent board that destroyed the single family status for Costa-Hawkins rent exemption, because you're essentially creating a triplex or a fourplex by renting rooms. Now, again, this applies to the rent control exemption. So in that scenario, that house and the rental of those rooms was subject to local rent control. Whereas if you have a traditional rental agreement to one family for the entire house, that would be exempt. Once you start parsing it up and renting rooms
on separate rental agreements.
Yep. Once you start doing that, whether it's oral or written, then you potentially come out of that exemption and are subject to local rent control.
All right. So generally, the multifamily landlords are subject to rent and eviction control, and they generally get this. The pushback we've seen is with homeowners saying, I'm not sure I want to be a landlord, and all the challenges. That's generally where we get the questions. The landlords are saying, hey, I'm subject to these rules now. We understand them, and it generally hasn't been the case. One final thing before we go, if you look at the regulations in the Oakland rent ordinance, it says if it's formerly been used as residential, and so if you have an illegal unit that's been used as residential, and let's say you get caught, you move the tenant out temporarily, you legalize it, you're still subject to rent control. So because you get a new certificate of occupancy with that space that you convert and go through the city, it doesn't mean that you're exempt from rent control. And I think people don't understand that. It's in the language of the rent regulations.
That's a good point. So a unit with a new certificate of occupancy, it's after 1996. So if you have a certificate of occupancy after January 1st, 1996 for a unit, it is, for most circumstances, exempt from rent control, notwithstanding local, strict laws on rent control. And again, this is another feature of Costa-Hawkins state law. Now, the exceptions to that are, as you pointed out, if you are converting a current existing space to a new unit and you get the permits and you convert it, so now you have a separate unit, you get your certificate of occupancy for that space dated, March 31st, 2022. Sorry, it's still going to be subject to rent control. Now, in the circumstance where perhaps you have added on to that structure, maybe you've added a floor, maybe you've added space in the back, and new construction, entirely new enclosed area, and you get a permit of occupancy for that space, then that particular space would most likely generally be exempt from local rent control when you get the certificate of occupancy now for that space. So it's a case-by-case basis. Maybe if you're converting a garage, for instance, which was never previously used for residential, in that circumstance, that may be exempt, but it may not. It really just depends, and it will vary from San Francisco to Oakland to Berkeley as well.
Great. All right, so reasons to legalize: boost your property value, get legal rent, which is a good thing, ability to get proper insurance, and increase the housing supply. So a lot of our issues and back and forth about landlord tenant issues is just lack of housing, and it creates a burden on the general population to house themselves, and it's just very costly. So let's talk real quickly about our process at Edrington at Adapt Dwellings. We can do feasibility studies. So if you're getting ready to help your client buy a building and you think you want to do an ADU, or your client thinks they want to do, give us a call. We can work with you during your due diligence process to help figure those things out. Once you decide that you want to move forward with an ADU, we have a licensed architect on staff who can design it. We understand City of Oakland Building Department. We understand San Francisco building department. So we can help you design it, get the approvals, and then work with your contractor to help you build it. We can do periodic inspections once the project's underway to help you make sure that the project's going according to plan, according to building code. So here's our contact information. Freedom Williams, I highly recommend them. Steve, we worked with you for years, and you guys know what you're doing, and highly recommend you. And I know everybody asked for the copy of the slides. If you'd like to get a copy of the slides, get your phone out and text "get slides" to 22828. That's text "get slides" to 22828. If you want to get on our email list, you can send this information to Edrington, info@Edrington and Associates, or info@Adapt Dwellings. We'll put you on our email list. We do a email out weekly, every other week, on general landlord tenant stuff and ADU stuff. So at this point, I want to go to your questions, and hopefully we'll have answers. Kieran, do you want to run the questions on us?
Absolutely. Thanks so much, the two Steves and Philip. That was a great presentation. So I'll just get started. We don't have too much time left in the until 1:30, which is a hard stop, right, Steve?
Yes.
So from Janisha Smith, we have, is there such a thing as grandfathered additions, and how does that work with regard to the most recent zoning and permitting rules? So this is a question about grandfathered additions.
Well, it's just, does a city recognize it as a legal structure or a legal space? And I think that's, so as long as the city's recognizing the space as a legal space, Phil, you might want to jump in and talk about that.
Yeah, absolutely. So grandfathered is a word that is actually a real thing. Grandfathered is something that was recognized by the building department at some point in time. Now, let's say, for example, we're living in a very, very old house, and it's got old electrical, it's got old windows, it's got old everything. That's all grandfathered in. If we want to do modifications to it, well, then we're going to need to bring those modifications up to code. Okay, and then they will no longer be grandfathered. But something that has already been approved by the building department, whether it meets current law and zoning, is grandfathered, and that's what that comes in. Just because it exists does not mean that it's legal or grandfathered.
Thanks, Philip. And oh, Steve, could you just go back to the slides, the text slide? There you go. All right. Next question here is, can you remove tenant parking to add an ADU? Elizabeth asks.
So Steve, Steve Williams, we had a discussion about this, and it's severing the housing service from the rental unit. And I believe, and I'll have to go back and look, you can petition the rent board to separate housing services, some housing services, to build ADUs. But then I have a question, like an ADA type question for you. So let's say that I have a disabled tenant. They park in front of in the building in front, the spot right in front of their unit. And for some reason, I want to take that unit, that space out. Let's say it's a carport or something, and I want to convert it to ADU. Couldn't the tenant say, I can no longer live there because you separated my housing services and I can't access my unit now because I'm disabled and I need that space in order to enjoy my unit, and could sue me for wrongful eviction? So I want to, we were talking back and forth on some of the things. I'd like to get your take on that.
And definitely. So, gosh, in the old days, we used to sever parking and housing services with a 30-day notice. Under state law, you can change terms of tenancy with a 30-day notice. It was that simple. Well, San Francisco got savvy and they changed their laws. They've made housing services a part of the tenancy and non-severable without just cause under the ordinance. Berkeley's done the same, and as recently as of 2020, I think it was, 2020, Oakland did the same. So it's not easy. You're probably going to have to try to negotiate or work something out with the tenant. But if you go in there and just try to take it, you do subject yourself to potential liability. And in that circumstance you just described, a potential wrongful eviction claim.
Now, my understanding, and I read that ordinance, there are some things that you can petition the rent board to reduce housing services. You want to talk about that a little bit?
Yeah, so that's a remedy for the tenant. So let's say you do go ahead and take that space. And the tenant says, well, whatever, they don't seek a lawyer and take you to court over it. The most common recourse for the tenant for reduced housing services is to file a petition with the rent board for a corresponding rent reduction. So in that circumstance, the tenant would then file their claim. Hey, I had parking, it got taken away from me, and so I'm entitled to a rent reduction. And then the rent board would make a determination as to whether or not that's true, which would be yes. And they would prescribe a value to that service.
Okay, and then the other, this actually came up in our staff meeting this morning. So somebody said, but I have my parking for the tenant on a separate agreement. I thought the rent board had a ruling that you can't have separate agreements on that.
I just got this definitively ruled on about a month ago. Any unclarity on that issue is now gone. Whether it's a separate agreement, whether it was entered into at the start of the tenancy or later, it does not matter. Housing services are part of the tenancy. Now, again, I'm talking about Oakland. In Oakland, they are part of the tenancy, and to sever them, no matter when they're added or whether they're part of a separate agreement, you're going to have just cause. And that's true in Berkeley and San Francisco as well. But I just got that definitively ruled on in Oakland, and it wasn't surprising because that's the way they've been doing things for years in San Francisco and Berkeley.
All right, well, let's move on from parking.
Yeah, let's. I'll try to get to some of these some of these questions that could be quickly answered. Here's one from Tiffany. Can an ADU be 2 stories if under the 18-foot max height restriction? For example, building over an existing garage.
Potentially.
Is that a yes?
It's a qualified yes.
Right.
Bill, do you want to comment on that? I don't know what happened to Phil. It's a qualified yes, because when we're over a garage, we're talking about multiple occupancy styles.
Okay.
Sorry, my poor little computer croaked.
Okay.
Here's one that I think that you went over, but let's just ask it for clarification's sake. From Cameron, how's lendability under Freddie and Fannie affected by addition of an ADU to a multi-unit property?
It depends on the style of property. If it's a 5+ unit property, probably doesn't matter. 2 to 4 it does.
Okay.
What happens is if you build an ADU on a duplex, triplex, or 4plex, you're no longer eligible for Fannie Mae, Freddie Mac money, and that's the cheapest money out there.
Gotcha. All right, here's a question from Janisha. Is a seller able to sell a home if there is a notice of violation regarding the home?
Sure, you can sell it. You disclose it. You just probably gonna take a discount.
Here is one from Max. Well, this is kind of a involved one. Maybe you can get back to it. Here's one from Leslie. Why would a tenant complain about illegality of a unit if it would lead to their eviction? And I think Steve actually kind of went over that kind of rift between landlord and tenant, and kind of, just kind of grows, right?
Yeah,
It's all good until it's not, right, Steve?
it could be leverage, and the tenant may not realize what they're doing by making the complaint to the city about that, hey, that may result in their displacement. They could just be looking for some leverage, but then it results in potential eviction, subsequent wrongful eviction lawsuit.
Steve, I've seen from some of the tenant lawyers is, from what I can gather, is that they're encouraging their clients to move out so they can claim the wrongful eviction and the treble damages and attorney's fees.
Yeah, that's probably smart if the tenants have the wherewithal to do that. Yeah, I mean that then solidifies the wrongful eviction as opposed to, potential or threatened wrongful eviction.
Right.
And it sort of sets the damages.
Right.
All right, great. So this one's kind of a little bit of an open-ended question. So maybe we can narrow it down. What are some of the implications, top-line implications for a buyer to purchase a home with a non-permitted unit? So give us some of the.
Hopefully you can get a deal on it. That's the deal. I mean, hopefully, hey, it's a non-permitted unit. I'm not paying full value for it. And you negotiate and say, I got to go through this whole permitting process. I got to deal with your tenant. It's in a and I got to do the eviction or, move them out, do all the work. And here's the other thing. If they're paying $1,000 a month, I hire Steve Williams to help me with my 60-day notice of terminating a tenancy. And if for a temporary basis, I go in and spend, say, $100,000 for sake of argument, right? Then I get to invite the tenant back, and I have to petition a rent for capital improvements, and I'm going to get 70% over the useful life of the improvements. So yeah, legalizing there's potentially pain and suffering on the legalization.
All right. Yeah, good point, Steve. So here's one that's kind of touching on the fire zone conversation that's been happening. Please clarify ADUs in high fire zones. My understanding is no separate structures like a B freestanding garage can be converted, but if the garage or area is part of the house, an ADU is allowed as well as a junior ADU. Is that correct?
My understanding, and Phil, you can jump in. Phil's walked over to my office because his computer died. As long as you're within the envelope of the building, you're good to go. And they don't want you to add additional structures in those areas. And Phil, on isn't length of street?
I was just going to say, yeah, there are some caveats. The length of the street, the turnaround at the end of the street. There's some specific rules about where you can and cannot add an ADU.
Right, and just think of it this way: they're looking at egress. So if you're up on Snake, I'm just going to use Snake because most of the realtors are familiar with that. And there's a huge fire. How does everybody get out to Highway 13 and exit? I mean,
right.
That's something that the city's thinking about from a fire standpoint. It's egress.
And we're talking about Oakland because I know Berkeley
Oakland
will allow a separate structure, a detached structure as well.
Well, they probably won't allow the detached structure. They might let you convert the downstairs into a separate unit, but they probably won't allow you to do a separate brand new structure.
Okay. Here's a pretty easy one. How do you get a certificate of occupancy? Where do you go?
Well, so it's part of the building process. So are we talking about an existing certificate? So I'll answer it 2 ways. If it's an existing building, go to the building department. They should have a copy of the existing certificate of occupancy in part of their historical archives, and they should be able to produce that for you. But if you're building a unit, part of your permitting process, when they sign off on the final permit, says final, then you ask them for a certificate of occupancy. And if they don't give that to you, the building permit, it says build new ADU, and the final will suffice as well. But I'd always ask for the certificate of occupancy as well.
All right, and we got another easy one. Hopefully, how have ceiling height requirements been changed recently? Have they been increased?
Well, no, they haven't changed. They're following the building code. So if the building code is 7.5 feet, the residential code is 7. San Francisco has not adopted the residential code, so it's 7.5 feet. So it depends on your jurisdiction, and it's following the building code. The cities are not making exceptions to the building code.
Okay. Now, let's see here. Can you build an ADU above a detached garage and still use the bottom as a garage or an office or a gym?
Potentially, but they're two occupancies. One's residential, one's utility occupancy. And there are a bunch of building code issues regarding fire separation.
In addition, that garage structure is probably not going to be strong enough. And so there's going to be some substantial rebuilding required to get that second story up there. ADU laws does have a top out. If you're just going to go with a state ADU law, it's a maximum of 16 feet, which is difficult to get a second story up there. Certain areas such as Oakland and other jurisdictions have raised that, and that makes it a much more viable option then.
Right, and so just the footing has to be, so you're going from a single story, like maybe a 4-inch slab for a garage, and now you're adding a second story, and you may need to modify the footing just to make the, because it has to hold up the residential structure above it.
All right, and it looks like we're rounding out coming up to the end of the presentation. One last question, maybe Stephen Williams from Freed Williams, Connor Grice can answer. How hard or easy is it to get a certificate of exemption from rental or eviction controls?
Well, that's just typically at Oakland in particular, it's just an application. You just file your application. You have to provide, the proof. For instance, it's a certificate of occupancy issued after a certain day, new construction. So whatever you're claiming is the exemption, what it's for, maybe Costa-Hawkins, you'd have to provide proof of that, file your petition, and then you'd have a hearing.
We actually did one for a client. He had an ADU down in the basement, and he wanted to put it on record that it was exempt. And we did it. I think we did a great job on the paperwork, and the hearing was 12 minutes. And they said, thank you. And they issued the certificate of occupancy, but it was clean paperwork, not a lot of paperwork. And it was just a matter of, we submitted it. They had a few questions. The owner went on record and saying, what the condition was. And they said, thank you. And they issued a certificate of exemption, but that was like the record.
No tenant opposition there.
Yeah, it was a unit inside his house, inside his house, and there was nobody to oppose it.
I had a comment. Hello, can you hear me okay?
Yeah, well, yeah, hold
I think
on.
that
We're actually
we've,
at the end of our time.
We ran out of time now, but if you do have a question, please email. You can email me directly. I'll put my email in the chat, and I will try to get everybody's questions answered that didn't happen to get them answered on the presentation today. So we have.
And you can email us as well on your ADU questions, and we'll try to get back to you.
Absolutely.
Okay. Okay,
all
great.
Right. Yeah, sorry, we're just out of time.
Okay, thank you.
All right. Hey, I want to thank all of our panelists. Phil disappeared because his computer crashed and he walked in my office. But Steve Williams, thank you. It's always a pleasure to see you. And Kieran, thank you for having us on. And we're also I'm part of the committee, and we've actually lobbied for the realtors on behalf of the realtors for the changes in the Oakland and Berkeley laws. So Kieran, you've done a great job on that, and we'll continue to be monitoring that and making suggestions to make it easier to add housing to our community. So with that said, thank you, and feel free to reach out to us.
Thank you, Steve, and thanks for all your help with all of the stuff regarding ADUs over the past couple of years. It's been a slog, but we've been getting through it.
It's been a slog. All right, thank you for participating, and we'll see you soon.
Thank you.
All right.